Welcome to all the listeners for this webinar on ISDS Reforms in the Information Age, a look at challenges and opportunities. We have a stellar cast of speakers to guide us through. Firstly, may I quickly wish each of the listeners health and safety in these trying times. I'm sure the circumstances we find ourselves in will weave its way into this discussion as well. We have with us Gary Bond, President of the SIAC Court of Arbitration and the Chair of International Arbitration Practice Group, Wilmer Hale, out of London. We have Pauline Njaro, who is an international lawyer in Nairobi, the Republic of Kenya. And we have Romesh Veeramantri, Counsel Clifford Chance, and Head International Dispute Resolution in the NUS Center for International Law. Without further ado, and a warm welcome to each of the speakers. Thank you for making time. The ISDS system has been the subject of much debate in recent times, and we have seen in particular UNCITRAL Working Group number 3 being inundated with reform proposals, both incremental reform proposals as well as radical or wholesale reform proposals. The UNCITRAL Working Group number 3 in times of COVID did something quite interesting, which is that they ran a series of webinars earlier this year on discrete aspects of the reform proposals that were before the working group. These included sessions on a multilateral instrument on ISDS reforms, both in terms of a substantive instrument as well as the procedural aspects. A separate one on treaty parties' involvement and the control mechanisms in treaty interpretation, the role of mediation in ISDS, and finally, shareholder claims or reflective loss claims in ISDS. And some of these themes would again be reflected in the discussions today. Today, we propose to have 3 broad topics of focused discussion. The first will be led by Romesh Veeramantri, on to enhance independence and credibility of the system. Finally, suggested reforms invite on conciliation. Please tell us more about it. And is this reluctance that is perceived in the arbitration world on the role of mediation equally applicable in your experience in the ISDS context? And how can you suggest that can be overcome? Romesh. Romesh, you might have to unmute, please.
To speak at this seminar. Can you hear me now?
Okay. Yes, we can hear you now. Thank you.
Okay, so it's a pleasure to be speaking here at this seminar. Thanks for the invitation. I was just saying I missed a bit of what you said. You broke up there, but I think I understand when we've talked about the topic about the role of mediation and conciliation in investor-state arbitration. And I'd like to sort of briefly survey some of the interesting developments in this field. So as you know, we have this sort of information age where everyone knows a lot about commercial, not commercial arbitration, investor-state arbitration, because it's public, it's on the internet, the decisions are on the internet. And what's more is, it's not just decisions, it's you have these awards which actually say and state how much, fees, legal fees were involved. These awards state, government responsibility in ways that certain people never would have expected. These awards reveal a lot of issues that now the public knows, and I think in, say, 15 years ago, those sorts of issues really weren't coming out. So these are new issues the public is aware of, and so you have a new call to sort of say, well, does this system really work? Because you've got these new sort of voices in expressing their thoughts about how the system should work. So that's why you hear a lot of debate in the working group at UNCITRAL, and you have a lot of observers who are non-lawyers and who have an interest in the area, and the particular area that I'm talking about, mediation conciliation, I think particularly comes in when we talk about the types of costs involved in arbitration, ISDS types of arbitration, the time involved, and also the decision making and the decision outcomes of these proceedings. So you've heard about the legal fees, in terms of the millions of dollars. It's not, and now we're talking about tens of millions of dollars. You're talking about timescales that have, up to 4-5 years, right, to resolve these processes. So these are sorts of parts of the concern, I think, that has been expressed about the system. And one of the areas that has been talked about to actually deal with this is to say, well, is there now a much bigger role for mediation or conciliation? Now, you're well aware that investment treaties, BITs, have consultation or negotiation requirements prior to the institution of an arbitration, but often, and it's seldom that that sort of process of consultation and negotiation leads to a settlement. You usually sort of, and the ones that I've been involved in, they don't really progress much, and a lot of people are just sitting there. It's a waiting time before you could start your arbitration. So there's concern about the effectiveness of that consultation requirement. So that's where mediation conciliation potentially could step in. Now, at the Centre for International Law at CIL, in 2016, Lucy Reed and Chris Thomas, they conducted a survey on ISDS and conciliation in the ISDS sphere. One of the main findings that they found was that states are more reluctant to settle. And again, I think that in my general experience, it seems to be an issue that needs to be looked at. Why are states not settling and going on to this arbitral process, which takes years or millions and millions of dollars in legal fees? So they wanted to sort of look at why this settlement wasn't happening, and they were looking at the obstacles to settlement. And in this survey, they sent it out to about 90 practitioners in the field, but practitioners who represented governments rather than practitioners who really focused on investors. And they received about 50 responses, and they conducted, and they compiled a sort of a report on this, and they found that the number one reason that government officials were reluctant to settle was that they wanted to, in effect, avoid responsibility for that decision. And they wanted to defer that decision to the tribunal. So in essence, there was this sort of thought that, well, let's just give this difficult issue to a tribunal or a third party. Let's essentially avoid the decision making. And so that's one of the reasons why the main reason from this survey that decision makers went to arbitration rather than settle themselves. And obviously the settlement needs somebody to sign off, and a government official needs to sign off. So that's where individual responsibility potentially, not in a broader sense, in reputational or professional sort of types of responsibility creep in. Now the second obstacle that was found in the survey was that there were fears of allegations of corruption coming in. A government official would sign off on a settlement, but then potentially there was a fear that they could be accused of being corrupt, of being sort of in cahoots with the investor by signing this settlement. So that was another concern. Well, that was the second most important concern. The third most important concern was a fear that the government official would be criticized. So there's this level of criticism that sort of creeps in, and this survey, the result was that, well, that affects this decision making, and that promotes government officials to want to go to arbitration rather than settling it themselves. And then the fourth most important or most frequent obstacle that was referred to in that survey was that by settlement, if you settle, potentially that would create incentives for investors to say, or other investors to say, hey, there's been a settlement here. Let's try and claim and get a settlement. So there was this sort of incentivization of claims fear that was reflected in the survey. The other types of issues, the other types of obstacles the survey recorded were within, and I think Pauline may talk about this, within governments, you have issues about cooperation, coordination. How do you coordinate between different ministries or different departments? So there were multiple stakeholders involved. So that it was difficult to actually come to a uniform position. And the other point that was made that I thought was interesting was it was mentioned that when you have a budget, the budget would be readily sort of provisioned for arbitration expenses, but the budget was very difficult. Often budgets would not allow for settlement or mediation types of activity. So again, that was another issue or an obstacle raised in the survey. So you have a lot of different issues here. It's a bit of a cauldron, and all of these issues are mixed in. But so there is a lot of reasons why decision makers say we'll defer responsibility to an arbitral tribunal. So more and more, I think that those sorts of reasons need to be looked at, investigated, and somehow how programs need to be put in place to try to overcome those obstacles if you're going to make mediation or conciliation a process which is going to be used often. So CIL is pursuing the results of this survey, and they're going to look at more ways of overcoming these obstacles, but that's a work in progress. And there are a number of other institutions that are trying to also engage in this type of process to promote mediation and conciliation. I know that the Energy Charter Treaty, they started with a guide for investment mediation in 2016, but they found that the guide was saying, well, how do you mediate? How do you appoint a mediator? So it was, how to conduct a mediation process. But they found that guide alone wasn't enough, and they weren't getting, success through that. So what they did was they devised a model instrument on management of investment disputes. So this was a much more practical type of guide, which talked about the people or the officials going into the settlement needed authority to settle. How does the state budget sort of work with all of this? How do you plan ahead? So there were much more constructive types of sort of recommendations or guidelines, rather than just saying, well, how do you mediate and how do you, conduct the mediation? So I think that type of more detailed, more practice-oriented type of approach to try to work out, well, what can be done to promote mediation and conciliation, I think in the future is what's going to happen. And as I said, CIL is looking at that as well, but there's a number of other bodies looking at that. The other aspect of this is a number of institutions are also trying to either revise their rules on conciliation or mediation or adopt new rules. So in the ICSID process, rules and the old ICSID framework only dealt with conciliation and not mediation. And now so ICSID are looking at that and introducing rules on mediation, which will run in parallel with their rules on conciliation. So that's a quite interesting development. And just, sorry, the last point that I wanted to make was that the Singapore Convention now, I think, comes into play. So you've got this international instrument like the New York Convention for mediation settlements that will enable enforcement. But I think a very interesting aspect of the Singapore Convention is that it's got an Article 8, which is reservations. And the Article 8 reservations says that a state making that reservation does not apply the Singapore Convention to agreements which it or its agencies have signed. So effectively, that's an exclusion of ISDS settlements through mediation or conciliation. So it's a very interesting reservation. And so far, 5 states have signed the Singapore Mediation Convention, or ratified the Singapore Mediation Convention. 3 have made this reservation, so it's quite interesting. Belarus, Saudi Arabia, and Iran have made this. So 3 out of 5 already have said it's not applying to ISDS types of settlement agreements. So it's quite an interesting development. So
thank you.
I think I've sort of canvassed as much as I can. I'm sorry I've gone over time, but I thought those points would have been of interest for the listeners. So thank you.
No, not at all. It's perfect timing, actually. Thank you for that. And I was there when the Singapore Convention was brought into effect. And it's not often that you see history being made. And to even think that Saudi Arabia and Iran can sign up to the same instrument, and many other states, and having more signatories than the New York Convention, indeed, it is an exciting moment. Although Article 8 reminds us that history happens in stages and not all at once. Gary, if I can bring you into this conversation, we heard from Ramesh the hesitations from the states, but from the investors' side as well. Do you see any hindrances at all in the deployment of conciliation and mediation techniques, or is it a wholehearted acceptance from the investors' side?
Thanks very much, Shreyas, and also thanks for the invitation to speak at this webinar. It's a fascinating topic, and it's a real pleasure to be speaking alongside the other panelists. I think it's helpful to take a step back as one thinks about the so-called reform of the ISDS process. I think it's helpful to take a step back because in many ways it's been an extraordinarily constructive and successful experience with ISDS over the last 40 years. Extraordinarily successful and constructive, I think, both for states and also for investors. I say that because the flow of capital which has been facilitated around the world has contributed materially to the improvement in living standards, to the increase in economic productivity in all parts of the world. I also think it's useful as one thinks about the costs of ISDS to always keep in mind the magnitude of the investment flows that have occurred over the last 40 years, and which in a sense, those costs of ISDS are incidental too. Those costs are part of what enables investment flows to occur. Unless investors, frankly, unless states believe that there's an effective dispute resolution mechanism for foreign investment, they won't make the investments, they won't receive the investments. And so whatever the costs of ISDS may be, it's essential to keep in mind the trillions of dollars in investments which they facilitate. I also think it's important, as one thinks specifically about settlement and conciliation and mediation as a means towards settlement, to recall that although there are obstacles to settlement, settlement actually occurs in a very substantial number of ISDS cases which are commenced. Empirical research, the most recent, I think, the most comprehensive being that of Professor Susan Frank, shows that in more than a third of all ICSID arbitrations and publicized non-ICSID arbitrations, settlements are reached between the host state and the investor. That's, by any measure, that's a very substantial degree of success, whether it comes in the initial cooling off period on the one hand, or during the course of the arbitral process on the other hand. And so I think, in a sense, the current system has already facilitated through cooling off periods, but also through the natural good faith of the parties, a natural inclination to avoid whatever the costs of ISDS may be, has encouraged and facilitated amicable settlements. I'd also say that that 1/3 successful settlements of all ISDS cases is itself a further confirmation of the success of the ISDS system. States, also investors, wouldn't be amicably settling their disputes if they didn't have confidence in the system, and if the system wasn't leading them to a mutually satisfactory result. I do think that there are ways, though, there are always ways that the current system could be improved, both by reducing the time and cost of ISDS proceedings, and also perhaps by improving the mechanisms by which mediation and conciliation take place. Firstly, I think one of the reasons that ISDS costs more than people would like, and frankly, people, states, and investors would always like things to be cheaper, but one of the reasons that ISDS costs more than people would like is because of the bifurcation or trifurcation of proceedings. Susan Frank, again, in her very comprehensive book on this, demonstrates that bifurcated investor-state proceedings inevitably cost substantially more than unbifurcated proceedings, and that only stands to reasons. I also think, frankly, states themselves ought to reflect sometimes on the wisdom of jurisdictional objections, which seem to be taken as a matter of course and insisted on being considered preliminarily as a matter of course, given the costs that incurs. I think if mediation were conducted in parallel with arbitral proceedings, and if the mediator were permitted on a fast track time scale to provide his or her view about an appropriate resolution of the case, that would address many of the points that Ramesh's and Lucy's study has revealed. If there was a neutral but fast track evaluation of the parties' respective positions that state officials then could take back to the respective ministries and say, we can go forward for another 3 years or 4 years with this arbitration, but here's what a neutral mediator with our best in mind concluded. We really ought to settle this. I think that would have quite constructive results, both from the investors, but also from the host state's perspective.
Thank you for that, Gary. And can I invite Pauline? Gary has made a very provocative suggestion to go beyond mediation and even have a neutral evaluation. You've been a representative of states, Pauline. Do you really conceive that states might agree to, let's say, PO number 1, name individuals who could act as either mediators or neutral evaluators for certain aspects of the case? Is that something feasible in your experience?
Well, if it's going to reduce costs in the long run, mediation can be considered with a neutral evaluation. I was really impressed by his proposal of having a fast track mechanism. If it would work and you have a mediation in parallel as you conduct the arbitration proceedings, it could be feasible. Well, Ramesh mentioned the fact that there are also concerns with mediation, especially the authority to enter into settlements, concerns that you could be perceived as corrupt. We've had to defend some cases where, to the very end, because of those concerns. So, because if you sat down and had a mediation and knowing the confidentiality of the process, and you informed the constituents that we mediated and came up with a settlement, the perception of corruption, especially in developing countries, would be there. But if you could get aside the negative perception that a mediated settlement would be perceived as corrupt, or having challenges getting the necessary approvals in most developing countries, it would narrowing down the issues. It would fast track the arbitration process. So I think there needs to be a weighing and balancing on having approved mediated procedures, good lists of mediators, having the constituents understand that it's available and can be fast tracked, and having the proper mandates on how to achieve the settlement, having scientific ways of assessing the values to be reached in case a state has to pay. And if a country is convinced that there is no case at all, then you go for arbitration. There are some cases where we've had investors come and say, we want to settle, but we were convinced that we had a case and we refused to have mediation, we refused to have the discussions because we felt that the cases were frivolous claims or wanted to take advantage of our resources. So there's a lot of weighing and balancing, especially now in developing countries, on whether to take mediated settlements and or arbitration, and it all boils down to the facts of the case and a country assessing its strengths and weaknesses.
Thank you for those pithy remarks, Pauline. Gary, if I can turn the discussion over to you to share your views on another conundrum, which is on the independence and credibility of arbitrators. There have been efforts to have codes of conducts for adjudicators and to have perhaps a permanent body of adjudicators as a standing mechanism. What are your views on the proposals that have been made to enhance independence and credibility? You're on mute, Gary.
Thanks very much. I'd like to begin by, in a sense, questioning whether, in fact, some of the proposals are meant to, I think the phrase was, enhance independence and credibility. And in fact, whether some of the proposals are, in fact, proposals to reform the ISDS system as opposed to either destroy it on the one hand or turn it into something very different and much less conducive to the objectives that it seeks to accomplish. For decades, investment arbitration has unsurprisingly proceeded with the same mechanism for choosing the arbitral tribunal that has been used for centuries for international, commercial, domestic, and state-to-state arbitration. That mechanism for choosing the arbitral tribunal recognizes the critical importance of getting a tribunal that both parties can have confidence in because of their involvement in its selection, and also getting a tribunal that has expertise and experience in the actual dispute that has arisen between the parties. The mechanism that has been used from time immemorial for choosing tribunals in state to state and international commercial as well as ISDS settings has been each party selects one arbitrator. Those arbitrators are required to be independent and impartial, but each party unilaterally chooses one. And the presiding arbitrator is then either chosen by agreement by the parties, which occurs frequently, or alternatively by a neutral arbitral institution. That mechanism has, in my view, worked exceptionally well, both in the ICSID context and otherwise. There have been virtually no successful challenges to the independence and impartiality of arbitrators, but when valid challenges have been made, they have been upheld and arbitrators have either resigned or been removed. The proposal from some states, not all states, both in Working Group 3 and otherwise, is to throw that system, which has worked well for the past 40 years and frankly, the past 40 centuries, away, and instead replace it with a system that I think we know quite well from other experiences doesn't work, both in terms of the proposals in Working Group 3, but also the European Union's investment court. The proposal is for one side in ISDS disputes, the state, to choose all of the members of the tribunal for, and I think this is critically important, for a very narrow and specific category of disputes, namely investor-state disputes. Imagine a domestic litigation process in which one party got to choose the tribunal entirely after it knew what the dispute was. Nobody would think that that was fair. Everybody would think that that is unfair and inequitable. And in some very real sense, that's the object of many states, perhaps, in efforts to so-called reform ISDS. Because what they want is, in fact, not independent and impartial arbitrators. They instead want arbitrators who they have chosen themselves in advance in order to obtain more favorable results. That is, if one is honest about it, the real objective of these proposals. And if one looks honestly at those proposals, they do not further the goals of investor-state arbitration or dispute resolution, because they give investors no confidence that there will be a level playing field in which they are treated equally in an adjudicative process. Instead, they are referred to a process that ultimately is little different from domestic courts, because it is at the end of the day the states that choose all of the decision makers. I think the code of conduct, which has been proposed by UNCITRAL and ICSID, suffers from defects as well. It's more difficult to discuss the code because if you've looked at it, it has so many square brackets and so many open issues. What it would do, though, while preserving the basic mechanism of constituting tribunals, that means each party selects one arbitrator who must be independent and impartial. The two co-arbitrators or the arbitral institution or parties select the presiding arbitrator. She also must be independent and impartial, and there's a challenge mechanism. What it does is it imposes potentially, and it's unclear exactly what the scope of these would be, a wide variety of restrictions. For example, restrictions against double hatting, restrictions against acting as an expert witness while one also is sitting as an arbitrator in investor-state arbitrations. It's unclear whether engaging in these types of activities would merely be an item for disclosure on the one hand, or alternatively an item for disqualification. What is clear, though, is that the process of constituting an arbitral tribunal and of conducting subsequent challenges to members of the tribunal would become vastly more cumbersome, and there would be significantly more challenges to arbitrators. Going back to what Pauline and Ramesh said about the importance of reducing costs in investor-state arbitration, I wonder if that is in fact a sensible way to proceed. I think that if one wishes to reform the ISDS system, then the better approach is that by the ABIA guidelines on conflicts of interests and a more transparent challenge process, which nonetheless retains the benefits of expedition and efficiency. I think by ensuring that arbitrators are independent and impartial and are seen by the public to be so, one enhances and reforms the process genuinely rather than throwing the baby out with the bathwater.
Thank you for that overview, Gary. Of course, and just to re-stress, because strong positions are being taken by various participants on this debate, that it's, I think, healthy to have these views being aired, but it is also equally important for us to make it clear that these are views being put up for debate, and nodding in acknowledgement of what we have heard doesn't mean nodding in agreement with what has been said. So with that caveat, may I first invite Pauline and then Ramesh. Pauline, Gary has made very significant points. One on the linkage between investor sentiment and the ISDS system. But equally, there are other examples where even without ISDS systems in place, investment has occurred. There is at least one African state which has been arguing to do away with it entirely. Now, of course, Gary also mentioned the so-called reform proposals by states is severely undermining the investor's perspective of credibility of the system. So could you quickly take us to what your view is as a state representative, Pauline?
First, in this webinar, in this seminar, I'm not speaking as a state representative, where I work for the state. And that's why I didn't come out very clearly that I work for the state. But Gary has raised very, very strong concerns, and which have made me reflect on where is the weighing and the balancing. He has said that it's not right for states to choose all decision makers as proposed by one large country, and that the process has worked for very many years, and he's concerned about the code of conduct. But where I come from, the cases we've had for the past few years, the system, selecting our arbitrators has also worked for us. It's not been a bad thing, because we'd look at the expertise, the type of case, and who is the best arbitrator to understand the issues and our issues from a developing country perspective. What I do wonder is the composition of, let's say, a standing court. How would you take into account of developing country interests? Because I've had to sit, and as I say, I'm speaking on my own personal capacity. I've had to sit and analyze, okay, this is a case. Who understands a village in a Kenyan rural part of a country? Who has traversed across Africa and understands our issues? And Kenya has a one of the best QCs who truly understands Africa. We call him. If I could give him citizenship, I would give him citizenship. So how do you weigh and balance having such mixes in a permanent court? When I look at the WTO scenario, because I'm also an international trade lawyer, the appellate body mechanism, you can see, has reached to a point where it's at a standstill, because some countries have felt that the current structure is not meeting the evolving times. So I think this is something that I've not been a representative of our country in the UNCITRAL III, but I follow closely. These are issues that countries have to really think about in the long run. will you end up having a standstill like what has happened in the appellate body mechanism? So how do you have a balance of having developing countries and developed countries adjudicators listening to cases? Because where I sit from a developing, an African, a lady, there is that bias. And I think that's why the developing countries are coming out shouting very strongly they want reforms. When will an African arbitrator be selected to, let's say, to sit in a panel with Gary Bond? I had a case where one eminent African lady, arbitrator and adjudicator, was asked to preside over a case, an ad hoc case under the ICJ, where one of the panelists left the case because he couldn't understand how a lady from Nigeria would be president. So I think if all these biases are dealt with and there's a level playing field, it would help in creating a system that will work. And those are my top of the line thoughts for now. Thank you, Shreya.
Thank you for your heartfelt comments, and especially the ones on diversity. They hit home, Pauline. Thank you. Ramesh, can you please weigh in on your thoughts? You've just heard very different thoughts from both Gary and Pauline. Where do you come out on the reform proposals, and or what are your comments? I don't mean to put you in a spot, but what are your comments on what's been discussed?
Thanks, Shreyas. Yeah, so I'll make some comments because I think that there's a lot of debate. But the first comment I make is investment arbitration, I think, has deep roots in the tradition of arbitration. As Gary said, there is this sort of arbitral right that's been established over centuries. When you look at Gary's sort of writings on arbitration that dates back for centuries, and this, it's the right to choose your arbitrator has sort of been a constant thread through most of the history of arbitration, especially in modern day. And so for the talk of a third, a body that will sort of impose an arbitrator on arbitration practitioners who are defending cases or bringing cases before that body, I think that is an issue, and it's a game changer in terms of how arbitration has been conducted. But I think just to sort of make the talk about the other side of the coin here, you have a system in the ICSID annulment process where you do have a system where arbitrators are appointed not by the parties but by ICSID. And my experience, and I'd be interested to hear what Gary's thoughts on this, but I haven't had overly sort of vocal criticisms about the choices made in ICSID annulment proceedings where the parties don't really have a say in the annulment committee members. So that's a system where it breaks from the traditional sort of right to choose arbitrators, and so there are sort of little universes out there potentially that could show how this could work. But one of the issues about a standing court to me is especially, and I think Gary's right, you've got this standing body of essentially arbitral judges. But my question is, and Pauline was talking about the state side, but from the investor side, who would be the very competent, sort of the best of the best type of investment commercial lawyers who are going to be able to give up their careers and say they'll become a judge on this sort of investment court? I think there'll be, you know, quite a limited number of ably sort of qualified practitioners who represent investors or the investor's perspective that would be willing to sort of put aside their normal work and join the court. But that could be, I could be wrong, but that could be an issue. Trying to sort of, and that sort of is part of the issue about who will you choose to be on that court. So that's the investor side issue, I think, on that court. In terms of the code of conduct, again, you know, these codes, you know, Toby Landau sort of talked about these codes as forming this sort of disease called legislatus, where, you know, you put anything in a code and it sort of becomes law that everyone must apply. But, you know, even the IBA rules on conflicts, for example, each individual case, I think, is very different sometimes. These rules cannot be hard and fast laws, and sometimes they're looked and used as if they're laws, and I think that's something that needs to be avoided. So I think the code, you know, any sort of code of conduct needs to be looked at very carefully. Who drafted it? You know, what's its purpose and how it's going to be used. And then just the point that Pauline raised about diversity, I think that's, you know, obviously it's a very important point. But the issue is, it's who appoints, right? So who appoints these arbitrators? I think, you know, that's where a lot of the diversity issues, I think, would be addressed. It's up to the actors who appoint arbitrators that need to sort of see this, and I think the ball is a lot, you know, is significantly in their court to actually appoint on the grounds of diversity if they want to. But that, you know, I think that's where a lot of the focus should be on the appointments.
Thank you for those comments. And Gary, before we come back to you on the SID point, we'll please turn to Pauline for the last segment of this discussion. Pauline, I understand you're not speaking from a state counsel perspective, you're speaking as an international lawyer, and that is well taken. But even so, there have been proposals, principally from states, as Gary noted, that have come up throughout UNCITRAL Working Group number 3. And some of them innovative, some less so. But could you please walk us through some of those changes that particularly states have recommended, be it longer cooling off periods or a most favored nation, most favored option for states to achieve a broad consensus? And what are some of the pitfalls that you see, particularly for economies which are developing and for smaller states? So I leave it there for you to lead us through those reforms proposals. Pauline.
Well, of course, developing countries have had huge complaints about the ISDS period. And Ramesh mentioned the issue about cooling off periods when discussing the issue about the ability of mediation and challenges with bureaucracy. Of course, longer cooling off periods would be very, very appropriate, especially when it comes to investor-state disputes involving developing countries. Because by the time you get a request for arbitration, I remember handling a case where a request of arbitration had gone to 3 different ministries before landing on my desk. And be sure probably a month has passed or 2. So because of the bureaucracy, because once a request of, most likely the request of arbitration will be sent to the ministry, not even copied to the Attorney General, and they'll be figuring out what do we do with this. And by the time they bring the request to the right office, a long period has passed. So you are working on a race against the time and trying to file for cases out of time seeking the out-of-time permissions to file from the tribunals so that you can protect the state's interests. That would hardly give you time to even sit and discuss with the other party. So I believe that longer cooling off periods would be very, very appropriate for developing economies due to the challenges with the bureaucracies, the capacities, even trying to figure out where do we get an arbitrator, where do we get a good lawyer, how do we discuss this with the other party? And that would give time for the states to plan strategically, to think through, to look at the issues of the case. Do we go for mediation? Do we go for conciliation? Or do we just go ahead and defend the case? The other issue you raised was having multilateral instrument. A mechanism that requiring binding interpretation. The issue of cases having different forms of interpretation in cases has, of course, caused a huge issue, has of course caused huge furor in the international arbitration system. There is need to find consistency in coming up with interpretations, especially of cases where there are similar facts, but different rulings have emerged from different tribunals. I know this has happened in cases in ICSID. I've seen this happen in other cases in different arbitration forums. How do we come to consistent interpretative approaches of treaties? And also this boils down to the selection of the tribunals. How do we get the right tribunal? And that is probably why the proposal of having a standing court came up with, because having different tribunal members with different jurisprudential outlooks also contributes to the different interpretative mechanisms. So how do you have a balance to have tribunals that will be consistent in interpretation of cases with similar facts, several cases with similar facts? Of course, I know developing countries have raised the issues of double hatting. Of course, especially also, not only developing countries also, but also international lawyers of repute like Philip Sands. I know he's been against double hatting for very, very many years. Because how we feel is that with double hatting, I will be inclined, if I'm counsel and arbitrator, I'll be inclined to be very measured in my approach so that the big law firm can pick me for another case. Let me call it a subtle form of corruption, for lack of a better word. The influence. I'm speaking, having sat in an arbitration where we are all government lawyers, and the other side we have a big law firm, and you can see sometimes how the tribunal is measured, and you wonder, is this tribunal member being so good? And you can see the facts are very clear. Is he being so good so that to get another job from the other side? So the issue of double hatting is a big issue for developing countries. As much as there are people out there who feel that it's not a big deal, but it is, because the subtle influence. And I think that's the reason why some cases we prefer arbitrators as arbitrators, not an arbitrator who is also a counsel.
Great. And on a slightly lighter vein, you now have the prospect not only of double but triple hatting if there's, and quadruple hatting if you have mediation positions and early neutral evaluation positions opening out. But at the same time, somebody has to make that transition at some point in their lives. And at a particular time frame, it may seem that they're wearing many hats, but again, it's also sometimes part of a journey. Thank you, Pauline, for making those comments. Did you have anything further?
I'm thinking also of issue of the question you raised on a reform measure to make it a more fairer system. Ramesh mentioned very clearly that that on the issue of diversity, it's for the countries themselves, the parties themselves to select. So in Africa, we are encouraging African countries to give African lawyers and African arbitrators an opportunity. I know there's been a very, very clear, because I also sit at the board of the NCIA, National Nairobi Center of International Arbitration. I sit at the board and I represent the Attorney General. We are passing a voice very clearly to our fellow African countries, regional arbitration bodies, and to consider African arbitrators in their cases. And we've done that in a few cases. Of course, we are of course, before then we had challenges in getting lawyers who have a strong background in international law, international arbitration, international commercial law, and the upcoming lawyers. And that voice is being clearly passed because no one will select you. You have to select your own. And that's one of the best ways we are thinking of trying to bring ourselves to create diversity within the system. So thank you so much.
Thank you for those comments, Pauline. May I take it straight away to Gary before coming to Ramesh for his comments. So Gary, there were of course several observations that Pauline has made, but most emphatically the one on double hatting and the need for consistency. While of course there may be different views on double hatting, the need for consistency is surely a uniformly felt need across all sides of the equation. Would you have any further comments on this, Gary?
Yeah, by all means. I think it's important as we think about consistency to remember the extraordinary diversity of the subject matter of ISDS. One's talking about the entire globe, quite literally, with its considerable diversity. One's talking about 2,500 or so bilateral investment treaties and a half dozen or so, even more, multilateral investment treaties, all with their own terms. In a fair number of cases, those terms have, notwithstanding what some states now say, been negotiated with considerable care. There are important differences between the terms of different bilateral investment treaties. Some treaties have fork in the road provisions, other treaties have exhaustion of local remedies requirements. Some treaties have fair and equitable treatment clauses that specifically incorporate a historic minimum standard of treatment. Other treaties have fair and equitable treatment clauses that do the opposite. It's entirely appropriate that there be inconsistent results, if one puts it that way, when those different treaties with inconsistent rules are applied. I think it's also important, and therefore seeking consistency in a world of extraordinary diversity is in fact not
I think we're having some technical difficulty in hearing Gary. Ramesh, are you able to hear Gary?
No, he dropped out 20 seconds ago for me.
Yeah, you want to carry on with your thoughts till we get Gary back on?
Oh, he's back.
Okay, Gary's back. Gary, you cut out about 30 seconds ago. Yeah.
Okay. So I was saying just in summary that imposing consistency on a world of deliberately inconsistent treaty provisions and protections is in fact to disregard what states have carefully negotiated, what what investors have relied on and what makes sense for specific regional and local conditions. Second, I would underscore the fact that the investor state system is young and developing. It's easy to make mistakes as one finds one's way, but attempting to adopt a one-size-fits-all approach at the outset risks very significant mistakes. Perhaps I have a predilection, perhaps on this panel it's understandable, for a common law approach where one finds one's way based on individual factual circumstances. But I would hesitate very much to attempt to prescribe a single uniform rule and a single uniform set of dispute resolution mechanisms for all states and all pairs of states in bilateral investment treaties around the world.
Thank you for that very interesting perspective, Gary. And Romesh, you said you had a few thoughts either on consistency or double triple hatting issue.
Yeah, just to echo Gary's thoughts about the investment treaties, which, my experience is that you just cannot take a treaty on the face of it. You have to look deeply into the words of the treaty, and most of them are different, be it one word out of place or several sort of sections that are differently worded. But that has an impact, and everyone, that's why you get the the different inconsistent results from investment tribunal decisions. But the other factor is it's not just the difference in the wording of the treaty. I think it's also differences in the way that the case has been pleaded, the differences in the actual factual matrix that's behind the claim, and also the evidence that's presented. There are so many variations and variables, and the system is open, so you have access to all of these awards, and you have PhDs written on so many awards that are available, and it's easy to criticize, but I think it's much more difficult to actually sort of be an arbitrator in this context, because there's a lot of sort of issues bearing down on an arbitrator, not just within the case, but outside of the case. And obviously, the arbitrator needs to think about the case he's dealing with rather than external factors. But there is that pressure. And the other point, I thought, with that sort of inconsistency or the consistency issue, it reminds me of the decision by, I think it was Jan Paulsen in Pantechnicki against Albania. And he talked about, and I think it was a full protection and security type of issue, but he was looking at the state of Albania and saying, look, you've got to look at the state also, and look at the individual state. And that sort of gives rise to me an issue about, well, do you treat states differently in say the ability to offer full protection and security? Are less developed states, do they have a different standard that applies to them, or do developed states have a more stricter standard? But all of these issues, I think, come to play, and they're all displayed in public in these awards, which are easily accessible to everyone to comment on. So I don't think it's an easy solution, and I don't think one court is going to help solve that, because you'll have, I think, different opinions about how that court's going. If you have judges on a court that are actually appointed for a long term or a significant amount of time, and they start producing decisions which are unfavourable to a lot of people, what happens then? And you're probably back to square one, where you have criticism of the system again. But again, it's great. I think the discussion is great. It's very, very good to have this discussion. And let's see how UNCITRAL copes with all of the forces pulling it in different directions.
Yeah, thank you for that. We're coming towards the end of our session, but there have been a few questions that have come through. The first one is an observation from Kennedy Odiambo, who's raised the comment that in his view, an independent mediator in ISDS cases early should be encouraged, and it helps take care of front-end issues in some arbitrations which are not hotly contested. I think there is a certain category of issues, certainly, for example, extent of discovery or valuation methodologies, or some discrete aspects of an arbitration, which may well be potentially resolved. May I invite comments quickly from the panel, each of you, beginning with Pauline, Romesh, and then Gary?
Well, I agree with his proposal that there is a place for mediation, especially where issues are not hotly contested, when it comes to evaluations and assessing the costs, damages that don't need to really go before a tribunal. So there is a place for mediation. And that's why the cooling off period, a good cooling off period, especially I'm going to speak from a developing country perspective, would be important to enable narrow down the issues. This one we can agree, these ones we don't agree, and so we move ahead to arbitration. Yeah.
Now, thank you. And it's, of course, important for us to constantly remind ourselves of, as Gary said, the diversity of the world we live in. And in the context of Kenya, be it the Bomas or then be it other parts of non-cosmopolitan parts of the world, when some of these debates are conducted. Thank you, Pauline, for reminding us of that constantly. Romesh, your views, if any, on the comment that has been made?
As I said, mediation is a very, very good mechanism, and which, if used effectively, I think, and if it avoids arbitration, that's great. If it avoids it earlier than later, that's even better. You're saving costs, you're saving time. And the other issue, I think, with all of this is that with the settlement, it's agreed, it's voluntary, it's agreed, and hopefully both sides consider that's a fair way to move on, get over the dispute, move on, and have a constructive future rather than a destructive future between two battling parties.
Before we move away to Gary, there's a quick question that's just come in. So Romesh, you want to quickly comment on that, and then Gary can take both. What are your views on the asymmetry in ISDS on account of the fact that investors don't have the same obligations as states? It's a standing consent for arbitration, as they say, and that the states have a greater set of obligations. Romesh?
Sure. Well, I think that needs to be seen in the context of what investment treaties are designed to do in terms of attracting investment. And so I suppose its history, has shown that it's the investor that was catered for in these treaties, and that's where the focus was. But yeah, obviously, states cannot bring their claims, but more and more, you're getting obligations that are being imposed in investment treaties on claim investors, and you're having obligations. They're a bit soft at the moment in terms of human rights compliance or other types of compliance. But I think that there is probably a trend. But I think the historical reason why you had these treaties was to give investors comfort, and it was focused on the investor. But things are changing, and treaties are changing. That might change, but I think it'll take a long time for states in treaties to have the same rights as investors.
Thank you, Ramesh. Gary, your comments and both questions before we give the last word to Pauline.
Yeah, just very briefly, investor-state treaties are meant to correct an asymmetry rather than to create an asymmetry. The asymmetry is that, of course, the foreign investor's investment is subject to the unilateral police power and regulatory authority of the host state, and the foreign investor, by virtue of her foreignness, requires protections. That's the reason you have 2,500 bits, and before you had the 2,500 bits, It's the reason that you had exceptionally in customary international law and treaty practice protections for aliens, for foreigners, including foreign investors. The investor-state treaties correct that asymmetry where the foreign investor was relatively powerless vis-a-vis the host state by giving the foreign investor a relatively limited compared to the host state's inherent authority set of protections. That said, investor-state treaties often permit counterclaims by host states, and there have been a number of cases where, depending on the scope, jurisdictional provision, and the host state's desire to use it, counterclaims have been asserted for investors, and when they have failed to comply with their obligations, whether under an investment contract or under applicable law in the host state, that's entirely appropriate.
Thank you. Pauline, any brief and final comments from you?
Well, I'm just listening to the divergence. Gary has very strong points on the treaties are meant to correct the asymmetry, but I think things have changed now. And the upcoming treaties should also, and I think are now having obligations for investors, because some of these investors have GDPs equivalent to an African developing country. I mean, it's very rare to really find a case against a developed country. So there should be now a balance of obligations for both the investors and the states in the new generation treaties. Well, I do accept in the older treaties, like the BATs I've seen developing governments sign, the obligations were more on the states. But now, if I were to draft a new treaty for my country, there would be a balance of obligations for both investor and the states to create almost a symmetry, to create symmetries if possible. Thank you.
Well, with that sparkling debate over the past 75 minutes, it leaves for me to thank each of the panelists profusely for sharing their time and expertise. Thank you, Pauline. Thank you, Gary. Thank you, Romesh. And a big thank you to Wolters Kluwer, who has very kindly hosted this webinar. I suspect this is part of a series, given the extent of debate. And we did have a fourth speaker who had to drop out and who wanted to speak on the digital economy, but that will have to wait for another day. So with that, good morning, good day, and good evening to everyone who's listening. And may you stay safe and well. Thank you for your attention. Bye-bye.
Thank you, Shreyas. Thank you all.
Thank you.
Thank you all. Goodbye.
Thank you. Bye.